Alaikum, thank you for having me here tonight. I know it's a late night, and even though tomorrow's a holiday, I'm going to try to make it short and sweet and keep it very simple. I brought some mints for any of you who want mints. It's, I know after dinner, the breath, you can start passing these around. But I like giving stuff out so people don't get too bored, and especially for an 11 p.m. lecture, people don't fall asleep. So the mints have caffeine in them. Okay, so as the brother was saying, my practice, I've been practicing for 12 years now, and my practice primarily consists of three areas. The first one is real estate. Real estate is very broad. It composes of buying and selling property, residential, commercial, evictions, closings, leases, development, site development, litigation, boundary issues, title issues. There's a lot of stuff to do with real estate. Short sales, foreclosures, modification, the list goes on and on. Anything to do with property is pretty much all we do. And most people know real estate. It's very self-explanatory. When I say I'm a real estate attorney, they pretty much know what I do in regards to real estate. But these other two areas is where I have the hardest time explaining what it is. And I don't know if it's our culture or if people in general just don't know what it is. And this is what I'm really going to focus my time on. Not the real estate, because a lot of you know what real estate is, but these other two areas. Estate planning and asset protection. So I think first what we need to do is define these terms. What is an asset? And I like having an engaged presentation, so please, if you don't mind, I'm going to be asking questions and feel free to answer. What is an asset? Very simple. If you had to define it in 2 words. Yes? Something of value, exactly. An asset is something of value that can be traded, bought, and sold. Okay? An estate consists of assets and what? Any guesses? Liabilities. Correct. So all of us right now have an estate. Some of you have an estate with just assets and no liabilities, and that's very good. But a lot of us have assets and liabilities. That's the estate part of estate planning. Now let's talk about the planning. We plan our mornings, we plan our days, we plan our vacations, we plan our businesses, we plan everything. But do we plan what we're going to do with our assets and liabilities if we're not there? That's the biggest mistake I see, is people plan everything, but they don't plan that part. Well, how do you plan what to do with your assets and liabilities? Where are the assets going to go? And who's going to pay for the liabilities? Okay? That's what estate planning is. The planning of your assets and liabilities. That's one component of it. If you don't plan for your assets and liabilities, the state of Florida will plan for you. So imagine, if you will, you build up your estate, you have assets which include cars, land, businesses, stocks. You have liabilities which include maybe mortgages, debts that are owed on the business, notes, and all of a sudden you disappear. Where do those assets go, and who's in charge of the liabilities? Well, according to the state of Florida, we have a process here called probate. And what probate is it when the state administers those assets and liabilities. And based upon Florida statute, the state determines who gets those assets and who pays for those liabilities. For those of you who have been through probate, you're probably familiar with how arduous the process is. Got to go to court, an interested party, someone who may want some of the assets, or someone may be owed some of those liabilities, can open a case. A judge is appointed. A judge will then appoint a personal representative, which is the person who's in charge of the estate, to carry out and distribute those assets and make sure those liabilities are paid. Okay? That's called probate. Now, probate is not a good thing. Not just in America, but most everywhere. Why? First of all, it's public. When a probate started and someone passes away, all of the assets, all of the beneficiaries, or the people who are entitled to the assets, all of the creditors, or the people who have claims and liabilities, anyone can find out who they are by simply going to the courthouse and looking in the cases. Okay? It's public also. It being public is a bad thing, because the people who are owed money know about the probate, and they have an opportunity to file a claim. You owe me money. I found out that someone passed away, so now we're going to file a claim in this process. Probate takes a long time. Probate has many lawyers. There's a lawyer for the state. There's a lawyer for the person who passed away. There's a lawyer for the people who are owed those assets. There's a lawyer for the people who are owed debts. So if you have a lot of lawyers, you have a lot of costs. You also have a lot of time. So let's say a probate is opened. A judge will administer the estate itself. And then you may say, well, I did a will. Don't I avoid probate? No. What a will does is it simply provides instructions to the judge who's administering this estate. Your assets, your liabilities. Now we have a set of rules that will guide us to who gets the assets and who gets the liabilities. Everything else remains the same. It's still public. It's still a very long process. You still have people fighting, and you still have all these lawyers involved, but all you have now is a set of instructions. Okay? There's a few ways to avoid probate, and this is where the planning kicks in. And again, I can't emphasize how much we plan for every day of our life, for so many things that go on, but so many people fail to plan about this. Easiest way to plan, let's take an asset, piece of property. If I die, I want to make sure my spouse has that piece of property. So how do I do that and avoid probate? I put the property in husband and wife's name with something called right of survivorship. And what that means is if I pass away, automatically my wife will own that asset. Okay? The same thing could be applied to cars. The same thing could be applied to bank accounts. But what about stocks? If you own stock in Apple, or if you own stock in a company, how is that treated? Any guess? Same. Exactly. You could put a stock in husband and wife's name, and if wife dies first, then it goes to husband, and if husband dies first, it goes to wife. What about LLC interest? Business interest. Interest in partnerships. People usually assume that it'll work itself out. Somehow it'll get to the wife. I own an LLC. The LLC owns a piece of property. The LLC is in my name. How is that LLC going to become my wife's if her name isn't on it? It can't. It'll have to go through that probate process. So that means if you have a building, or you have a business, or like me, you have a practice, which is the major source of income, and something happens to me, and I own the practice, then there's no way that practice is ever going to go into my wife's name, because she's not on it. The only way she's going to get any income from that is through the probate process. Okay? So, in order to protect those that you love and those that you care about, you have to do this planning. And it's an exercise. And a lot of people think, oh, I'll just put stuff in husband and wife's name, it'll automatically convert. It doesn't work that way. Every time I see a probate client, they've missed assets. And we have to go through that probate process for a piece of property in North Carolina, or a stock that they got when they were young and they kept in their safety deposit. And the problem is that everything else they've done right, but even for this one thing that may be worth $5,000 or $10,000, you have to open this court process, you have to get the judge, you have to get people appointed. So it makes things very, very difficult. Planning is key. What's the best way to avoid probate? Not by having a will, but by having something called a trust. And what does a trust do? A trust is very simple. I like to use this. A trust is a box that you own. And in this box, you put all your assets. You put your car, you put your property, you put your house, you put your land, you put everything in this box. And while you live, or during your lifetime, husband and wife own this box. You're in charge of it. But the box has a set of instructions. And the instructions say that if either one of the spouse, the husband or the wife, passes, then the other will be in charge of the box. If both pass, then you'll have something called a successor trustee who's in charge of the box. If that person can't do it, then someone else becomes in charge of the box. And so what you're doing is, the box and everything in the box, the contents remain the same. It's just the people that are in charge, that are managing this box, that are going to change. The other beauty of a trust is that you can have a set of instructions, which you can't do in a will and you can't do in probate. Those instructions can say, if, God forbid, me and my wife pass away, then my children could get the contents of the box when they're 25, or when they graduate college, or when they get married. Whereas in a will or in probate, if something happens to both spouses, then immediately the children will get the assets. And if the children are minors, then the court will appoint someone, a guardian or a custodian, to manage the assets for the children, for their well-being. With the trust, you have more control. And you can dictate when your children receive those assets. The best thing about a trust is by doing this and having this box and having these instructions, you avoid probate. You don't have to deal with the judge. You don't have to deal with the courts. It's completely private, it's completely confidential, and it's seamless. And so, myself, I've seen the difference between probate and trust quite a few times. I wish everyone can go through that experience, because in probate, finding heirs, finding children, finding people, getting people to come down is very, very difficult and time-consuming. Whereas in a trust, it's very simple. One person goes away, the other person steps in. So, my advice to anyone who's considering and planning is to go with the trust. To make sure everything is in the box. Now that's the biggest mistake I see, is that I get clients that go to other attorneys and they spend thousands of dollars and they create this trust and they get this box. But the box is empty. There's nothing in it because they failed to transfer assets into it. And if you do that, then the box is meaningless. Okay? So it's important to put stuff into the box. How do you put stuff into a box? Well, if you own property, you use a deed. And you transfer the deed from your name to the trust. Everything remains the same. You can sell it, you can sign it, you can mortgage it, you can do whatever you want. But all you're doing is transferring into the box. A car, you transfer title. Boats, same way. Stocks, you transfer the stock from yourselves individually to the trust as trustees. Nothing changes. LLC interest, same thing. So it's very easy to put items into a trust, but this to me is proper planning. And this is planning for your assets and your liabilities. But there's also other part of planning. Guardians, right? Everyone says, well, if something happens to me, my wife's going to take care of my children. But these days, with all the plane crashes that are happening and all the craziness that's going on, you never know if something's going to happen to both of you. So it's important to appoint guardians. If you don't appoint guardians, guess who's going to appoint them? The state. Okay? Healthcare surrogate. Someone to make medical decisions for you. Something happens. I was talking to a brother. I'm going to Africa. If God forbid something happens to me in Africa, I need someone to be able to make a medical decision for me. Who are they going to go to? How will they know who can make this medical decision for me? You have to have these documents in place. To me, it's carelessness and negligence to not plan for these things, because it can happen to any of us. We spend nights and nights praying at the mosque and preparing for the afterlife, but the afterlife, we never know when it's going to come. It can happen tonight, it can happen tomorrow. This, to me, is negligence for not preparing for the afterlife and for your loved ones who are going to stay behind. So please, whether it's with me or anyone else, simple documents. You can find them online. You can use LegalZoom, healthcare surrogate, will, trust, and guardians. Okay? Any questions so far? Absolutely not. No. There's no recurring cost. Once you set it up, then that's it. If you ever need to change a trust, you don't have to change the whole thing. You simply do an amendment to the trust. So if another child is added, or if someone gets married, then all it takes is one piece of paper, amending the trust and changing that paragraph that you want to change. It's very, very simple. The hardest part about the trust is it's more work in the front end, establishing it, putting stuff inside of it. But especially when you're young, later on in your life, you'll see it's the best thing that you've done, because it becomes very natural. Everything goes into the trust. You buy and sell from the trust. You don't have stuff laying around. And that's the biggest mistake I see. Yes?
What takes precedence in that, trust or the will?
If you have a trust, the trust will take precedent. But the answer to your question is whatever you did last. Okay? So if you prepared a trust in 1976, and then you have a will in 1994, most wills say that anything I've prepared before is now considered void, and I revoke, and the current document will be the controlling document. So it's the last document that you've prepared. So a good attorney, what they'll do is they'll prepare a trust agreement, and with the trust agreement, after they help you put everything into this box, they do something called a pour-over will. And what that is that if I left something out, my stock I got from AT&T when I was 15 years old, then the will automatically capture it like a net and put it back into the box. It's called pour-over. So if that one thing you have to go through probate for, because it's not in the trust, but it gives the judge instructions to put it back into the box. So a lot of times you'll see a trust and a will, but that's called a pour-over will. Yes? It's the same thing. So there's two types of trust. One is called revocable, and the other is called irrevocable. So a lot of people ask me, well, I'm getting sued, or I have a malpractice claim. If I put everything into my trust, will it protect it? A revocable trust means exactly what it sounds like. You put it in, you can take it back. You have control over the trust. There's no protection there, because just as you put it in, you can take it back. An irrevocable trust, though, means that once you put it in, you can't take it back. And what a lot of people do for protection purposes is they create an irrevocable trust. The person putting stuff into the trust is called the grantor. So let's say I have $1 million, and I put it into this irrevocable trust, meaning I can't take it back, but I can have a trustee who is a good friend, who is a family member, who will basically do whatever I say, and I can be the beneficiary. The beneficiary is the person who gets the benefit of the trust. Okay? So in any trust, there's three people that you should be aware of. The grantor, the person putting into the trust. The trustee, the person who's in charge of the box. And the beneficiary, the person who's going to get the benefit. If all three of them are the same person, it's an invalid trust. But usually, in an irrevocable, the grantor will put money in there, the trustee says, I'm in charge, I can do whatever I want with it, and the beneficiary can be this person. So if there's $1 million, and this person is getting sued then this person can say, look, I gave my money to the trust. I don't have control over it anymore. Now it's the trustee who has control. So therefore it's not mine. But if this was revocable and they're getting sued, then they can say, well, you have the right to take it back. And because you have the right to take it back, it's not really protected. Okay? So to answer your questions as far as taxes, it depends on whether it's revocable or irrevocable. If it's revocable, it's treated as the same, just like you own it. If it's irrevocable, then the trust becomes a separate entity, and they have to file their own tax return. And so it becomes like a separate company. And it's the trustee's responsibility to file that tax return. Now, I also get the question, well, what if this trustee takes this $1 million and runs off? The trustee laws in the state of Florida are about 100 pages thick. And there's criminal violations if they don't act in the fiduciary interest of the grantor or the beneficiary. So what that means is they can't run off and go buy themselves a new car. Because if the grantor finds out, they can put them in jail. They have to work in the best interest, kind of like an attorney, kind of like a banker, kind of like an accountant, in the best interest of the grantor. Yes?
What's the difference between irrevocable trust and protective trust?
A protective trust is the same thing. A revocable is a trust that you can take back, the one I just mentioned. Irrevocable, a protective trust, you have something called a protector. Okay? And a protector is basically you in the trust. And you're in the trust documents and you tell the trustee what they can or they cannot do. So in that situation, if a court says, trustee, you have to release this funds, a protector can say, no, I don't authorize a trustee to do that. So it's one more person in the asset protection arena, which we're going to discuss, that can control what a trustee can do. That's called a trust protector. Okay? So if you remember anything tonight, remember, planning. We plan for everything. Make sure you plan for your estate. Who's going to pay for your debts? Where are your assets going to go? You don't want the state of Florida to make those decisions for you. You don't want the state of Florida to say, these are the people who are going to take care of my kids. You don't want the state of Florida to say, hey, public, this person's passed away. If he owes you any money, come to court, put a claim on it. Let's drag it out for 3.5 years. You don't want that to happen. What you want to happen is exactly what you want to happen, and the only way you do that is through a trust. All right?
What is the process of establishing a trust?
Trust, depending on the complexities. Now, there's many, many different types of trust. There's revocable, there's irrevocable. There's something called special needs trust. And a special needs trust is if you have a special needs child and you want them to get the government assistance, then you create a trust that either pays them the minimum or doesn't pay them at all so that they qualify for the government assistance. Okay? Because it changes based upon their assets and their income. So if I have a child and there's special needs and the government finds out there's a trust and they're going to inherit money, then the government isn't going to give them any assistance. With the special needs, you can control that. There's something called a land trust. A land trust is simply the way to transfer land between one owner to the other. The famous example for the land trust is Disney. When Disney came down to Orlando, they were buying acres and acres and acres of property. And if one person found out that the Disney Corporation is buying property, then everyone around them would raise the prices, right? Disney's paying $1,000 an acre, then everyone's going to raise the prices on there. So what Disney did, which was very smart, is they used land trust to buy several acres. And by doing that, you had here's a trust again, the box. You had, let's say, me as a trustee. Disney is the beneficiary, and Disney is the grantor. So I can call this trust ABC, and I go and I buy some property. Disney gives me the money. And then we create another trust, and we call it XYZ, and I buy the neighboring property. Disney gives me the money. So what Disney did is they set up 50, 60 different type of land trusts, and they bought all these properties so the neighbors never knew it was the same person. Because you can hide the identity of the grantor as well as the beneficiary. The only person that needs to show their identity is the trustee. So to answer your question, a trust can range anywhere for a land trust, which can cost $500, to a special needs trust, which can cost $2,000 because of the complexities involved. Your average run-of-the-mill trust, revocable trust, you're probably looking at between $1,200 to $1,500. But I promise you it'll be the best investment that you make, again, whether you do it with me or anyone else, for your family. And most good attorneys won't just do the box and the trust. They'll do the complete package, which is the guardian documents, the living will, their health care documents. I mean, a lot of these things, the living will, the artificial life support. Everyone remembers Terry Schiavo, where the husband wanted to take her off of artificial life support, and the mother and father wanted to prolong her life. And she was stuck in the middle until it went to the Supreme Court case. If she simply would have done a living will that says, I do not want artificial life support, I do not want to prolong my life using food and water, then it would never have been an issue. But because she failed to do that, you got caught in the middle. And I know it's a morbid topic, but during those time periods, why would you want to add additional stress to your family members? Take care of this stuff in the beginning. Okay? Yes?
Any of the trust documents get filed in the local courts?
Nope. That's the beauty of the trust. It doesn't get filed. If you sell property, then sometimes they'll need something called a declaration of trust to make sure that the trustee is authorized to buy and sell property. So they'll ask for one page, but the contents of the trust remain private. And unlike a probate, no one knows who the grantor is. No one knows who the beneficiaries are. It's not. Nope. And wills aren't even registered. A lot of people think, I'll go register the will in the court. You don't do that in Florida. You don't register it. The only time you register it is when you die, when you have to do a probate.
Yeah, in a simple situation, let's say most of your assets are jointly owned.
Correct. Yep.
You still keep them each for a trust. And would your spouse be the trustee or the other way around?
So let me answer your latter question. Your spouse can be the trustee, and usually that's the way you do it. You have a box, and husband and wife are the ones who are in charge of that box. But in the simple situation, if you just, let's say, you have a house, you have maybe an investment property, and you have some accounts, as long as you put everything in husband and wife's name with right of survivorship, that's key, then it'll transfer between each other. So what does that mean, right of survivorship? Well, I buy a house. I'm an unmarried single man. I buy a house. 3 years later, I get married. My wife lives in that house. That house is considered homestead because it's my primary residence. But because I didn't buy the house at the same time with my wife, because I didn't put her on title, my wife will have to go through probate to get that house. Okay? So it's very important that when you have it's a simple estate, you have assets such as property, such as your house, husband and wife are on the deed together at the same time. And you do that by saying property is owned by husband and wife. You either see it as tenants by entirety, which is a way of owning property, or with right of survivorship, one or the other. But people do that all the time. And a lot of times you put everything, you think property, land, but there's always other assets you forget, such as bank accounts, such as 401ks, such as stocks. That's the one I see most of, LLC. You see people that say, okay, I have a building, I want to protect my building, I own my building in this LLC, and I own it by husband, and the wife's out here, and if something happens to husband, there's no way the wife's going to get that building unless you go through this process called probate. And during probate, that building may be wasted, that building may fall apart, but the wife can't do anything about it. How do you fix that? Husband and wife own the LLC interest as husband and wife or as tenants by entirety.
In the case of, you mentioned
Mhm.
we always list the names of the beneficiaries.
Correct.
Right? So there's the first beneficiary, and then in the event that that primary beneficiary dies,
Yep.
then you have other secondary beneficiaries.
Correct.
So isn't that enough? You still have to create a trust for that?
Okay.
By the same token, talk of assets like cars, it is jointly owned.
Right.
Okay? And in your will, you have indicated that all these assets are jointly
Yeah.
and so on. She's the primary beneficiary. And check of any other, let's say bonds. And if you buy a bond, a government bond, okay? Apart from the primary beneficiary, you also have secondary beneficiaries indicated there. Is that not enough?
Yeah. So I understand I'm speaking to the senior committee, right? I'm obviously not a senior. So to answer your question, let's use a scenario. Let's say I have $400,000 in my 401k. Primary beneficiary is my wife. Secondary is my children. I have 3 children, so let's say it's each of them. 33%. Something happens to me, automatically goes to my wife. Something happens to both of us, my children are minors, where does it go? What is my 1.5-year-old going to do with $150,000? The court's going to have to appoint a guardian. The guardian is going to manage those funds in their best discretion. They can invest them, they can do whatever they want, but they have to use it in the best interest of that child. And when the child turns 18, then they get a check. But let's say I don't have a minor. Let's say my child's 21. So I don't know how many 21-year-olds there are in the room, or how many of you have 21-year-olds, but would you want your 21-year-old to get a check for $200,000? And what do you think the first thing they're going to do with that? So, unless they're Mark Zuckerberg, they're probably going to spend it. So it's great you have the primary and secondary, and everyone thinks, well, what are the chances of both me and my spouse are going to die? We have the Malaysia plane crashes. We have all these things that happen where people are dying like this. And if you don't have a trust, then your children immediately get those assets. And there's no control mechanisms. Whereas in a trust, you can say, no. If my child is 21, they don't get anything until they're 25. Or they only get a third when they graduate college. Or they only get a third after they get married, and then they get the rest at 35 or 40. So it gives them some control. The other issue that I've seen is the children lose motivation. If they know they've got that money, why do they need to go to school? They live off of it, and next thing you know, they've blown it. So those are some of the things that you need to be concerned about. You work so hard, you build up the estate, you want to make sure that, God forbid, something happens, you have control over it. Okay? Did that answer your second question as well?
Yes. The second part was that in the light of all secondary beneficiaries, do you still have to create a trust? If the assets are not that much.
Yeah, if the assets are, if you have simple assets and you don't have that many assets, then you can still plan with your estate without creating a trust. Okay? So if all you have is land, then you can have land with husband and wife. And even if you don't, even if you can still plan, let's say this is your house, husband and wife. Even if something happens to both of you, you can do something it's called a life estate deed. And basically what that means is the husband and wife own this property during their lifetime, and after they die, it goes to these remainder men, the children. And this is a simple trick, a life estate deed, which people who don't have large estates and don't have complicated estates can use to make sure that things that they own go to their children and avoid probate. It's called a life estate deed. During my lifetime, I own it, but after I die, it goes to my children. The key is you have to put certain language in the deed. And if you don't put that language and you don't identify your children in the deed, then they're not going to get it. It's called a life estate deed. So there's a lot of techniques you can use where you don't have to use a trust. You can use things like life estate deed. You can use primary, secondary beneficiary. You can do all these things. But as long as you plan it, and you don't keep property in your name only, or in your wife's name only, then there's things that you can do. So, I don't want to, planning is not just you have to get a trust. Planning is looking at what you have and saying what's the best way to distribute your assets.
Nishad Khan can do that.
And yes, Nishad Khan can do that. Absolutely. Okay, any questions on estate planning? Okay, so what I'm going to touch on next is the asset protection, the third area of practice that I do. Real estate, estate planning, and asset protection. Okay? What does this mean? Very simple. What's an asset? The gentleman said something of value. Protection? How do you protect it? You've created or earned or developed something of value in your lifetime. You don't want someone to take it from you. Who's going to take it from you? The crooks, the bad guys, the government, even worse than the government, the lawyers. Those are the guys who are going to take it from you. Because those are the guys that see you as a bullseye. This person has an asset, this person has money, we're going to go after them. Let me give you an example. I have a client, very nice Hispanic lady, who accumulated several properties while she lived here, 4 or 5 properties. She had one house, and they're all in her name. Okay? She had a house in Miami with a tenant in it. She was looking to sell that property. The tenant didn't want to move. The tenant always complained, there's something wrong with this, there's something wrong with that. You fixed it, and she kind of blew him off because she knew she was going to sell it. Well, she came to the house to go show it to a buyer. The buyer looked at it. The next day, the tenant went upstairs, took a hose in the attic, took grape juice, and filled it up, and then staged an accident. And contacted the lady and said, the roof collapsed, my child's hurt, I fell, my medical bills are in excess of $150,000. But if you give me a check for $75,000, we'll call it a day. The lady says, are you crazy? Why am I going to pay this guy? I know I was just there. The house was fine. Nothing was wrong with it. So what did this tenant do? He's in Miami. He went to Miami, found an attorney. The attorney went online, Googled, and saw that this lady owned all 4 of these houses. And these houses had no mortgages on it. They were free and clear. So the attorney filed a lawsuit and said, these are the damages that my client has incurred. If you don't pay us, then we're going to get a lawsuit, we're going to get a judgment, and that judgment becomes a lien on each of these properties, which means you can't sell them until you pay us. So she was stuck. She came, what do I do? She tried to transfer them into LLCs. It's too late. Once the lawsuit is filed, anything you do afterward is considered fraudulent conveyance. So what that means is it's subject to be reversed. A judge can look at that and say, you did that in order to avoid the lawsuit, it doesn't count. She had to cut a check. More than $75,000 to get rid of this person. All because she owned all of these properties in her individual name. It's that easy to see what you own these days. I can tell you what every single person in this room owns property-wise in about 3 minutes. And that's what they do, these evil lawyers, is they say, let's see what they own. If they own something free and clear, then let's go after them. They'll have no choice but to settle. Because that's the game. You settle. You scare someone until they settle. So how do you protect those assets? Well, the first thing I'm sure comes to everyone's mind is an LLC. How does an LLC protect it? Well, you put a property in an LLC, and let's say it's the same tenant. And let's say she owns the other properties in an LLC. Well, then the only person that this tenant with the roof that collapsed can sue is this LLC. Because that's the owner. It can't go after this one. Let's call this one D, C, and B. It can only go after A. And because of that, then she could say, fine, sue A. I can still protect these. No one can touch them. This is the only one they can come after. Okay?
These are 4 different LLC names.
Correct. 4 different LLCs. Now, you don't have to put 4 different ones. You can have 2 in one or 3 in one. It really becomes a business decision based upon the value of the property and the risk of the tenant. Okay? But by doing that, it's kind of like having a barrel of apples. You put a barrel of apples or a barrel of mangoes, put them in one. One mango goes bad. What happens to the rest of them? They all go bad. Whereas putting it in separate LLCs is like putting each mango in a Ziploc bag. So if one goes bad, it's in a bag. The rest will not go bad. And by doing that, you protect those assets. Now, most people go online on Sunbiz, open an LLC, they become the owner, and they say that's it, put the property in there. Fortunately, it's not that easy. There was a case that came down about 3 years ago that said if you open an LLC and you only have one owner, then there's no protection. There has to be at least one more owner, 2 owners, even if the second one is a small percent, for the LLC to be afforded those protections. Okay? So, a lot of people will open one LLC, me and my wife own the shares, and think that they're protected. No, you need one more person in there. What we suggest is you can have husband and wife own one, wife own the other, or vice versa. But changing the ownership and having 2 membership interests in the LLC will give you that protection. Now, when we talk about LLCs, there's 2 types of protections. One is the same example I just said, the tenant who's trying to sue you and trying to go after your other properties. But the other protection you have, same scenario, you have a property in an LLC, and let's say Nishad owns this property. Or you don't own the property, you own the LLC interest. Okay? I make that mistake too. People say, the property's inside the LLC, so I own the property. No, you don't own the property. You own the LLC interest. Okay? Just like if you own Apple stock, doesn't mean you own all their iPhones. You just own the shares of Apple stock. So Nishad owns the shares of this LLC. Nishad drives down the road, and gets in a car accident. And the person who I hit, let's say is a young person, and they get severely injured, and they want to sue me. They find that nasty attorney again, and they file a lawsuit against me. Well, if I had a corporation, right? Let's forget that this is an LLC. Let's just say it's a corporation, like stock, like McDonald's stock, or Apple stock, or any other large company, and that person sued me, and they won that lawsuit, then they can actually foreclose on my stock. They can take it from me, and that stock becomes theirs. But what an LLC does is you don't have stock. You have something called membership interest, which is intangible. You can't even touch it. It's just an interest in an LLC. And if someone sues my membership interest, they can't take it from me. Instead, they become me. They slide into my shoes. And what that means is they don't just get the income from this property, but they also have to pay the debts and the liabilities. So if the roof needs to be changed, they have to pay for that. If there's rental income coming in, they can get it. Whereas in the stock, if you own stock in Apple, I don't have to pay Apple debts. I don't have to pay Pepsi debts. I just get the income. And that's the beauty of an LLC, and that's the difference, is that you have that protection. It's called a charging order protection, which means you can't take the LLC interest, you just slide into the shoes, you have to pay you get the income, but you also have to pay the debts. And that's why a lot of people, especially lawyers, when they see ownerships in LLCs, they stay away from them. They're really looking at your liquidity. How much money do you have in a bank account? What kind of stock do you have? Or what do you have in your personal name? Because those are the things that are easiest to go after. Okay? So you always hear people, the protection of an LLC, protecting an LLC. That's the 2 protections that you should be aware of. But to do it right, make sure you have 2 interests in an LLC. And I see it all the time. People go on Sunbiz, they open LLCs. It's not the right way to do it. If you want to do it right, you have to treat it as a real business. That means opening the LLC, getting articles of organizations, getting tax IDs, getting operating agreements, and making sure all your governing documents are in place. Biggest mistake I see is Happens all the time. Here's a property in the LLC. Let's say Nishad owns it, but anytime the rental money comes, it goes into Nishad's account. And anytime I need to fix the property, it comes from a separate account. This isn't a real business. For those of you who have businesses, do you really commingle your personal funds with your business funds? No, you keep it separate. So when you're trying to protect assets in an LLC, you also want to keep your accounts separate. The LLC account should be standalone. Income comes in, expenses go out. Doesn't touch your personal accounts. These things help reinforce the fact that it's a true business, therefore getting the true protections of an LLC. Questions?
You also protect your primary residence, the homestead, or that's protected?
No. So homestead is, under Article 10 of the Florida Constitution, is a protection in itself. So if it's your primary residence, meaning you've lived there for 2 out of the 5 years, or you intend to live there, then you have such strong protections on your homestead that no one can take it. And the beauty of Florida, why a lot of celebrities come and buy houses here, is because Florida has unlimited homestead protection, as long as the property is under half an acre. If it's more than half an acre, then only the value of half an acre is protected. Okay? But under half an acre, or if you're in a rural area, 60 contiguous acres next to each other is completely protected. So people ask, okay, well, if I have a house that's on 2 acres and I'm not in a rural area, then what's protected? Well, the court would take the value of the house and then would take half an acre value and say that up to that is protected. The rest, they can force you to sell. But it's a very, very difficult process because the homestead protection is so strong, and to prove what that value is and to prove the contents of the house, no lawyer wants to go through that. So most people just ignore and say it's their homestead, we can't touch it. Okay? The other protection is tenants by entirety. I mentioned that phrase before. What that means is that if you buy something, anything, house, land, car, bank account, with your spouse as husband and wife, you buy it at the same time, using the same document, you have a protection called TBE. And what TBE protections means is that if the husband is sued and the person that's suing them is trying to go after something that's own TBE, they can't touch it unless the wife is also sued. Okay? So let's use an example. I own land. I own land by myself. I get sued by someone. That person can come and take that land and put a lien on it. Okay? I own land with my wife as tenants by entirety. I get sued by someone, they can't touch it. Because my wife is not a party to that lawsuit. The same rule applies to whether it's land, whether it's a bank account, whether it's stock, whether it's a car, whether it's a boat. Pretty much anything can be held as tenants by entirety. The problem is if that both of us get sued, and I see this when you have a physician and you have the spouse that's working in the practice as either an assistant or a secretary or whatever, when both of them get sued, then everything that they own as tenants by entirety is at risk as TBE. But if you don't have a situation, then I highly recommend. But to do TBE, you have to do it at the same time. So going back to the example, I buy a house before I'm married, or I buy a piece of land before I'm married, and then I add my wife on it later, I don't get TBE. I have to put both of us on the same time. And the way you do that is I take a deed and I give it from me to me and my wife at the same time. Not to me and then my wife. It has to be to me and my wife. And then I get TBE. Okay? Those simple little rules can make or break it.
TBE and provider survivorship the same thing or different?
So TBE is the same thing as rider survivorship, but it's limited to husband and wife. Okay? So in TBE, you and I can own a piece of property with rider survivorship. But to get that TBE protection, we have to be married. And this is why, the whole same-sex marriage is a big deal. Because these rules all have to change. And we have to go back and rewrite the rules because the TBE law says a marriage between a man and a woman. And now if it's a man and a man, guess what? Man and man has TBE. So it becomes very, very complicated, and that's why it's such a big issue, because you have all these laws that are preserved for man and woman. But TBE has right of survivorship, just limited to husband and wife. Yes?
You have an LLC, and you said you have two people. So if one of you gets sued, the company or the actor is still protected because there's two people and only one person is not sued?
Okay. So is it okay if I draw out your example? Okay, so you have an LLC. There's two people. Let's say there's A and there's B. A owns 50% and B owns 50%. A gets sued. What are they going to sue A for? If A only owns 50%, they're only going to sue him for the 50%. So the company is unaffected. The other owner is unaffected. It only affects how much they own.
When you incorporate TBE after the fact that you bought the house and your own name and that,
Yeah.
now you want to put that tenants in the entirety?
Yes. So here's a house. Husband owns. Husband gets married. What you do is you transfer this house to husband and wife as TBE through a deed, and that creates it. It's that simple. But some people just, there's a difference between that and husband owns a house, I'm going to add my wife to the deed. There's a difference between adding them and transferring it to both of you as TBE. And that's the mistake people do all the time. And what happens is they lose that protection. Yes? Sure. Two separate people? Yeah. Correct. So you can have an LLC with two ownerships as TBE. You can have wife and husband, 50% owner, and husband and wife, 50% owner. So now you have two separate owners because the wife is an owner, husband is owner, but it's husband and wife is husband, and they own as TBE.
So when you buy an asset like a car or a house, you buy it jointly, is that assumed tenants by entirety, or do you have to change it to tenants by entirety?
You have to change it to tenants by entirety, yeah.
Easy process?
Yeah, so if you go to SunTrust and you open a bank account, you tell them, I want the bank account to say tenants by entirety. You go buy a car, they go, what name do you want on title? Husband and wife as tenants by entirety, as TBE. That's simple. You have to do it when you purchase it. You can also do it afterwards, but you have to transfer it. So now you got to take the car title and transfer it from my name to me and my wife as TBE by going down to the DMV.
Another issue, when we talk about a rental process, the one in Miami, you want to rent a property, what kind of insurance that indemnifies the property against any lawsuit? Is there any special protection that you have, that you recommend?
It's liability insurance, right? But you have to be very careful, right? Insurance companies are in the business of denying claims. So they find every reason they can for not having to pay. The biggest mistake I see is people buy property for them to live in. Let's say they move to Orlando, they buy their first starter home, they want to start off and live in there, and they get insurance on it, and then they move out, buy another house, and they rent it. By renting it, they've converted that house from a primary residence to an investment property. And if you don't change the insurance, that insurance is going to say, you never told me you're going to have a tenant in there. That's a different policy, and that's a different premium, and therefore your insurance doesn't apply. I see it happen all the time, where they just think they can put in a renter and everything's going to be fine. You have to inform your insurance company. You have to inform your HOA. There's a lot of things that have to happen when you make that change. But liability insurance would cover that. My advice, if you can do it, is you get an umbrella policy to cover everything. investment properties, your car, everything else. And that's, your best protection.
This comes under liability also.
Correct.
Umbrella liability.
Yep, umbrella liability. Okay? Any questions?
If you want a company as a husband and wife, you said it's better to have as the
If you own a company as husband and wife?
LLC.
Yes.
It's better to have as the.
Yes.
Does that have any different tax implication, or is it the same?
No, the tax implication is the same. But I want you to understand why I say that. Okay? And what I love about this stuff, so again, the three areas I do is real estate, estate planning, and asset protection. But almost 99% of the time, all three of them become one. And this is a good example of one.
Muhammad Salat. Welcome to this presentation by Attorney Nishad Khan on real estate and estate planning. There are two topics which is going to cover today. The discussion will be over the sale and purchase of property, mortgages, loan modifications, foreclosures, and estate planning. At the outset, I must say that we like to, as a senior, on behalf of the senior committee, I would like to express our appreciation to Brother Nishad for accepting our invitation to address our community. Brother Nishad has graduated from the University of Central Florida in 1999 and received his law degree from Seton Hall University, New York in 2003. Nishad focuses his practice on all aspects of real estate law, including commercial development, landlord, tenant, residential sales and purchases, distressed properties, loan workouts, title issues, and financing. Nishad also devotes a significant portion of his time to estate and business planning, wills and trusts, probate, wealth preservation, business law, and commercial agreements. He started his own practice in 2007 in Orlando. During law school, Brother Nishad provided indigent clients with legal representation in areas of human rights abuse and political asylum, representing them before an immigration judge. After the law school, he spent a year with New York-based non-profit organization providing legal aid to victims of hate crimes and ethnic discrimination. Nishad is licensed to practice in the state of Florida and is a member of the Florida Bar Association. Nishad is a frequent speaker for the Orlando Regional Realtor Association, as well as many other real estate-related organizations. As a long-time resident of Orlando, something personal, Nishad also enjoys spending time on local bike trails and playing basketball and playing squash. I would now like to invite Brother Nishad to speak our community on these two topics. We have 1 hour. During this 1 hour, he will speak for about 30 minutes. After that, he will invite questions from on these two aspects, or two parts of his presentation, the real estate and estate planning. Please welcome Brother Nishad with salawat. Allah.
Alaikum, thank you for having me here tonight. I know it's a late night, even though tomorrow's a holiday. I'm going to try to make it short and sweet and keep it very simple. I brought some mints for any of you who want mints. It's, I know after dinner, the breath, you can start passing these around. But I like giving stuff out so people don't get too bored. And especially for an 11 p.m. lecture, people don't fall asleep. So the mints have caffeine in them. Okay, so as the brother was saying, my practice, I've been practicing for 12 years now, and my practice primarily consists of 3 areas. The first one is real estate. Real estate is very broad. It composes of buying and selling property, residential, commercial, evictions, closings, leases, development, site development, litigation, boundary issues, title issues. There's a lot of stuff to do with real estate. Short sales, foreclosures, modification, the list goes on and on. Anything to do with property is pretty much all we do. And most people know real estate. It's very self-explanatory. When I say I'm a real estate attorney, they pretty much know what I do in regards to real estate. But these other 2 areas is where I have the hardest time explaining what it is. And I don't know if it's our culture or if people in general just don't know what it is. And this is what I'm really going to focus my time on. Not the real estate, because a lot of you know what real estate is, but these other 2 areas. Estate planning and asset protection. So I think first what we need to do is define these terms. What is an asset? And I like having an engaged presentation, so please, if you don't mind, I'm going to be asking questions and feel free to answer. What is an asset? Very simple. If you had to define it in 2 words. Yes? Something of value, exactly. An asset is something of value that can be traded, bought, and sold. Okay? An estate consists of assets and what? Any guesses? Liabilities. Correct. So all of us right now have an estate. Some of you have an estate with just assets and no liabilities, and that's very good. But a lot of us have assets and liabilities. That's the estate part of estate planning. Now let's talk about the planning. We plan our mornings, we plan our days, we plan our vacations, we plan our businesses, we plan everything. But do we plan what we're going to do with our assets and liabilities if we're not there? That's the biggest mistake I see, is people plan everything, but they don't plan that part. Well, how do you plan what to do with your assets and liabilities? Where are the assets going to go? And who's going to pay for the liabilities? Okay? That's what estate planning is. The planning of your assets and liabilities. That's one component of it. If you don't plan for your assets and liabilities, the state of Florida will plan for you. So imagine, if you will, you build up your estate, you have assets which include cars, land, businesses, stocks. You have liabilities which include maybe mortgages, debts that are owed on the business, notes, and all of a sudden you disappear. Where do those assets go, and who's in charge of the liabilities? Well, according to the state of Florida, we have a process here called probate. And what probate is it when the state administers those assets and liabilities. And based upon Florida statute, the state determines who gets those assets and who pays for those liabilities. For those of you who have been through probate, you're probably familiar with how arduous the process is. Got to go to court. An interested party, someone who may want some of the assets, or someone may be owed some of those liabilities, can open a case. A judge is appointed. A judge will then appoint a personal representative, which is the person who's in charge of the estate, to carry out and distribute those assets and make sure those liabilities are paid. Okay? That's called probate. Now, probate is not a good thing. Not just in America, but most everywhere. Why? First of all, it's public. Anyone, when a probate started and someone passes away, all of the assets, all of the beneficiaries are the people who are entitled to the assets, all of the creditors are the people who have claims and liabilities. Anyone can find out who they are by simply going to the courthouse and looking in the cases. Okay? It's public also. It being public is a bad thing because the people who are owed money know about the probate, and they have an opportunity to file a claim. You owe me money. I found out that someone passed away, so now we're going to file a claim in this process. Probate takes a long time. Probate has many lawyers. There's a lawyer for the state. There's a lawyer for the person who passed away. There's a lawyer for the people who are owed those assets. There's a lawyer for the people who are owed debts. So if you have a lot of lawyers, you have a lot of costs. You also